Hello and welcome to today's episode of On the Mark Financial Literacy with Mark Zinman. Hello, Mark.
Hey, Monica.
How you doing?
I'm hanging in there.
Good, good. Hello, Alicia.
Hi.
Hi. Can we start with some definitions? What is a will, and when must it go through the probate process?
Okay, Monica, thank you for that question. Well, first of all, a will is left by a person who dies, which basically will tell their heirs or their executor how they want their personal assets and liabilities taken care of. And as far as the probate process is concerned, probate is basically filing the will with your county probate office. When does that have to be done? People always want to avoid probate. It's like the big thing out there, but it's not that uncomfortable a process. I happen to know in the county where we're located, the people are much nicer to people who walk in to probate a will than when lawyers come in to probate a will, who they already think should already know what they are doing. So it's neither expensive, it's neither time consuming, other than having to go to the county to do it, and they're very helpful. And when is that probate? Normally when there's real estate involved.
Okay, all right.
Sometimes banks might require a probated will. So there's all kinds of different terms. So there's death certificates, there's short certificates. These are all things you will get from the funeral home. And they have to be filed. Obviously, they want to prove that, how do you know a person died? Well, these are the documents, the legal documents that a person has become deceased. When someone dies, the funeral director usually notifies the IRS or the Social Security Administration. That's how they find out to stop if they were receiving, Social Security benefits. So the whole process starts usually through the funeral home.
And what about a trust?
So, a will is how you want to handle your assets, okay? And most of those assets go to a person, a charity, or something like that. A trust is an instrument to hold the money that has some restriction on what the beneficiary, the ultimate recipient, will get. So, for example, if for some reason you didn't want me to have, I know I'm in your will, Monica, as it is, but if you wanted to leave me all the money, but you're worried I'm going to spend the money, or I'm under the age of 18, or something, there's we can talk about special needs, there's all kinds of different kinds of trusts, then there will be rules about how much money I can get and for what things.
Okay, and what if someone disputes the will?
That would be decided. That's a very expensive process. You don't see it that often. I've been involved in several cases, some of which I think are ridiculous. But for the most part, then that would eat up a lot of the estate.
Okay.
I will say that I have seen things where, people will change the will to the benefit of somebody else. Well, let's say, for example, you left me 50% and you left my two other people 25%, and I decide that I want everybody to have a third. You can do that. Mm-hmm. You're basically gifting your share of it, but you can't do the opposite. You can't say, well, you left me 50, I want 100. That would be a contested will.
Okay, all right. Now, what can we do to make it easier for the executor or executrix to administer the estate and to distribute the assets? So talk about documents and document storage. What can you and I do to make it easier for our executors to handle that administrative burden?
I would say that 90% maybe of people have lawyers do the will, but really you can just theoretically download some type of a document off the internet or a format and write your own will. Let's keep in mind that the things that don't go through a will would be things that have a beneficiary. Life insurance, retirement accounts, they all have beneficiaries, and regardless of what the will says, the beneficiary trumps, okay? So if you're going to make a will, first of all, you would need an executor. And that could be a child. It could be a close friend. It could be a relative. It could be two people. It could be a family member and a professional. I'm a co-executor on several of my clients' estates. I've been asked to do it, and it's possible that when the children get older, they feel more confident, I would be dropped off. But I'm basically there to handle the non-emotional part of it, and the family members there to handle the emotional part of what the person's wishes were. So, but you definitely need to tell the person that they are the executor of your will. And you should even go further to tell them what's in the will. I mean, it shouldn't be like on TV where the family gathers in the office of the lawyer and they read the will. I mean, that just doesn't happen with ordinary everyday people, and it shouldn't happen for anybody, really. Everybody should really know what happens when mom, dad pass.
Okay. So we have a will potentially, and we have perhaps a life insurance policy and other documents. Where should they be stored?
Well, usually a will is stored, the lawyer who drafted it would have a copy. So if you have a family attorney, that would be a good place to look. It could be, safe. It used to be in the safe deposit box, but I don't know how many people have safe deposit boxes. I think that if you put your important papers in a certain place and then you told them where that it's, on top shelf of my closet, or our passports, some people have filed with their passports in it, and, warranty for the refrigerator and their will, and, all the stuff that the settlement sheet from their house, what they consider important papers would be there. Paper's less important than it used to be. I mean, a lot of things like, you have to have a certificate of deposit to know what bank it was. Most of the stuff's online now. So it's not the same combing through everybody's closet and sock drawer to find where mom or dad might have hid something.
So regardless of what format it takes and where it is stored, it's just important that your executor knows where to get a copy.
Yeah, there shouldn't be any secrets with wills. I mean, you don't have to tell everybody, but you definitely have to tell the person that you. Listen, if for somebody's unhappy with the will, who do you think they're going to take it out on? The person you left. And you don't want to ruin relationships or make it any harder. And listen, there are two components to somebody dying. And somebody who's sick for a while and then dies is a different kind of death than someone who suffers a sudden event and dies, an unplanned one. And what's the difference? Well, neither are good, neither are fun, but one you expect and one is you didn't expect, and it adds to that emotional component, which feeds into what we're talking about because it's a lot. I think the worst cases that I've seen are ones where, so this is an interesting phenomenon. In marriages, there's usually one of the two spouses is the financial spouse, right? They're the ones that pay the bill, take the checks, and the other one feigns they have no interest in it or really have no interest in it, one or the other. If the financial person dies, the non-financial person is left with the emotional loss of the person who died and a complete lack of understanding of it, are they okay? Mm-hmm. And I see this happen in my practice. And in both cases, it was a sudden death of a husband. One was on the operating table. Another one was a heart attack at home. And it's just that just needs special handling. And that's why, even though we don't like to talk about it, we have to always prepare. My wife's real good at this. We're going to go on a vacation for our anniversary this year. And the first thing out of her mouth after we booked it is, we need to update our wills. So apparently, every time we go on a big trip, every few years, it's time to update our wills.
And we want to talk about not just the distribution of assets, but if there are any minor children in the household, we want to talk about who their guardians would be. And is that something that would be in the will?
Yes. And let's just talk about what is the job of an executor or executrix, okay? Your job is to gather all the assets and inventory of the decedent and handle the orderly distribution of those. And what are the most common things? Retirement account, maybe life insurance, bank accounts, and usually the most complicated one's a house. Okay? Because you could certainly close a bank account, you can have a bank or financial institute the rollover of funds to another person, but you can't always get the household in a week. And you got to clean it out and whatever. So, hang on one second.
And not just the distribution of assets, but the executor will be responsible for liabilities as well.
Yes.
Yes, medical bills, you mentioned if someone should fall ill.
Just think about it. Audience, close your eyes since you're listening to me anyway. Close your eyes and think about it. You're gathering all of the all the assets into a centralized place. Okay? You're going to liquidate them to the you have to make a decision if you're going to liquidate them to cash or keep them in there, distribute them as like stocks and bonds, right? And then you're responsible for all the obligations of the decedent. That could be paying inheritance tax. More than likely, if there is inheritance tax involved, because we discussed this before, it's not federal, since most of my clients and most people listening probably don't have more than $25 million in assets. So it's mostly under your state. And you'd be filing an inheritance tax return in your state. And what are you supposed to do? You're supposed to pay off all the debts of the decedent. You make sure all their taxes are filed. The responsibility, so they call it a fiduciary responsibility. You're a fiduciary, you're an executor, you're a trustee. A trustee and an executor are actually the same, just the same thing with a different name because they're a different instrument. So you have a higher threshold of responsibility than the person who was signing that stuff. And where do we find problems at? Unfiled gift returns is probably the biggest one. Now, fortunately or unfortunately, the IRS hasn't been as effective as it has been in prior years. But in reality, everyone is allowed to gift, I think the current number is $18,000 per person, to anyone without any consequences to the recipient. And there are no tax consequences, income tax consequences to the donor. So, but people have to remember, it's $18,000 total, not $18,000 and then you buy them a shirt. Okay, it's $18,000 total. If you go over that $18,000 number, you have to file what's called a gift return. What's a gift return? Basically, it's to keep people from giving away all their money in contemplation of death to avoid estate taxes. Okay? So even though estate taxes are now $25 million, you still are required to file a gift return. So if you gave your child $100,000 to help them buy a house, that's a gift. What's the gift? Well, if it was given to, you count the number of people who give and the number of people who receive, right? So if two people gave, that would be $50,000, husband and wife, that's $50,000 each. If they gave it to daughter and son-in-law and daughter, that's two more people. So what was the gift? The gift was 18 times 4 is 72,000. That would be exempted, and then the difference to 28 would be the gift. And basically what you're doing is you're counting now backwards down from that $25 million number. So where do we find unperfected gifts? Adding people to bank accounts is the most common one. So if you know, mom or dad are getting older and you're helping them with the bills and you say to them, you know, I'll put you on the account. There's two different ways. You can be an authorized account user or your name can be on the account. So if you gave me the right to Monica to sign checks on your behalf, I still don't own any of your money. If you change the title of the bank account to Monica and Mark, now I statutorily own 50% of what's in that account. And so that was a gift.
And if you are a signer on the account only, are you responsible for any debt? Do you have any liability there for that?
Virtually none. Virtually none. There are some places where if you're a responsible party for paying, I'm trying to think from in business, right? Like sales tax, trust fund taxes, sales tax. Sales tax is the most common one. It have to be 401k that you withheld from an employer, and you were responsible and you didn't turn the money over. You could be held personally responsible, but I can't really think of anything in the realm of individuals off the top of my head.
Okay. All right.
You have more. There's more liability. There's more liability by mom and dad adding your name to that because of a couple of things, right? We just made an unperfected gift, and now we have an asset that could be attached to the creditor of your child. Okay, so everybody does it. It's like that funny thing, you know. I can't tell you how many people come and all of a sudden, I had a joint account with my mom. Well, you had it for the last 5 years, and it was an unperfected gift.
So I think in a future episode, it would be nice for us to discuss, you, let's say, put your child on your account and your child has debt, and then can that debtor collect off of that joint account. So I think that's a little bit off topic for today, but would be a great thing for us.
Right. I think the whole thing about, I just want to make, I guess the point is, and I probably got about 3 minutes carried away on it, is basically one of the responsibilities is of the executor is to make sure everybody's taken care of. Yeah. Returns filed, it's accurate. It's just funny that if you think about it, a fiduciary responsibility is a higher level of responsibility than just being the person. Mm-hmm. Okay, and remember, you're liable to the heirs. Mm-hmm. So even your siblings, if you do something, wrong, you could be held personally liable. So it's an important role. It's not that hard. You just have to, and you need a professional involved. Depending on the estate, I don't want a bunch of emails from attorneys. I think that you really don't always need an attorney, especially when we're only talking about the kind of simple assets we've talked about here. You got family trusts and, a very wealthy family. Yeah, you need an attorney.
Don't go anywhere. We'll be right back after a quick break from today's sponsor.
Looking for financial clarity and support you can trust? Zinman & Company is your one-stop solution for all things accounting. From tax planning and bookkeeping to HR, recruitment, and outside controllership. Whether you're an individual, a small business, or growing fast, our expert team is here to guide you every step of the way. Zinman & Company. Smart solutions, personal service, real results. Visit zinmanandcompany.com to get started today.
But you don't necessarily need an attorney for the simple ones. We here at Zinman & Company do a lot of like mom and dads and guide people. And the other thing I'll share with you is never hire a professional who charges anything but by the hour. There's attorneys are allowed to charge a percentage of the assets, and you don't want an attorney to charge a percentage of the assets because the cost of that professional would be dependent on how much legwork the executor is willing to do. And you can get a fee for that, but if you're willing to go to the county office and probate the will and the lawyer doesn't do it, you're saving hundreds of dollars, right? If you're going to get an accountant to prepare the inheritance tax return instead of a lawyer, maybe there's just some savings there. But at least you have choices. Mm-hmm. And you can pick and choose what you want and how much time and what it's going to cost. Good.
All right. So we're talking about, you're providing some helpful information about what to do if you find yourself as the executor or executrix of a will. I know we also wanted to talk today about who should have a will and what event might trigger the writing of that first will.
I want to talk about, can I back up and talk about when you had mentioned trust and I didn't address that more. So we had talked about there being executors of wills and trustees in trusts. So I already said earlier, you more than likely have a trust if you wanted to restrict the use of the money. And 90% of that times it's because there's minor children involved. It could be, the only other thing we see often is you want the money to stay in the family, so you don't want a spouse to have a right to that money, so you put it in a trust. Sometimes
by a spouse you mean an in-law.
An in-law, yeah. So, but I've also seen, and I've advised clients on that, if maybe you don't want to give it to them if they're only married 5 years, but maybe you would be okay if they're married 20 years. The length could count. So there could be an end to the trust. All these trusts could have an end. The end could be when you're 21, 30, 35, when you're married. There's all kinds of triggers to end trusts. So it could be the same reason in that. And I'm not suggesting to anybody that they should do it or shouldn't do it. I'm just saying that's
a little rough.
Yeah. But basically, an executor of a will would have a very narrow window of when their duties are, right? It could be a year and a half. It's just basically, you're talking about in a normal one, getting all the accounts together, paying for the funeral, paying any of the expenses of the decedent, selling the house, cleaning the house out, blah, 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 and then you're done, right? That's 18 months would be, it depends when the person dies because you may have to file a tax return for the estate. So that's another thing to understand. So, Monica, you're Monica, okay? And Monica, filed a tax return. Now, you get hit by a bus today, okay? You're no longer, Monica's gone. Now it's the estate of Monica. That's a completely new taxpayer, okay? And you have to file a tax return as the estate of Monica from the date you pass away, and you have a choice whether that is a calendar year or a fiscal year. But the return can't be longer than 12 months. So what we often talk about with executors is how long do you think it'll be before you get mom's house out? If you think you can do it within 12 months, we'll wait and file one return. If you don't think you can get it done in 12 months, then we're going to have two, right? The year that they pass, which would be less than 1 year, and then the next year whenever you get it done. But an executor, a trustee of a trust may be in their job for a long time. I'm a trustee on a trust, I think I'm in around 10 years. And, I'll just give my experience. This was a trust set up by a client who really had no family members who she felt were financially equal. And so she named me the trustee. I'm the sole trustee to 3 of her nieces. And she had different rules for all of them. One was younger, so we were the money was able to be used for school, housing, whatever. The other one was very worried about. He could only have the income from it, no principal. So I will share with you that he's asked to have his roof fixed. He's asked to buy a car. It's tough being a trustee sometimes because you have to. And that's another thing. So a trust is another legal document, and in the trust it'll say what you can and can't do. And there is some discretion. There shouldn't be, but you basically are trying to follow the wishes of the person whose trust you're representing. And that could last longer. So I just want to make sure I gave a difference here.
Yeah.
Okay. And depending on who the trustee is, like there could be fees involved in that. You can be compensated for being a trustee. There's usually provision in there. There is something you can do. You have to make sure the tax return's done. You have to make sure that rules are followed. I get calls like for the one I'm talking about. I get calls like once a year about distributions, and I have to approve them and sign off. So it's not a lot of time. I don't want to make it sound horrible, but yeah, there's something involved. Now, your next question was who needs a will, right?
Yeah.
So let's keep in mind what doesn't go through a will: life insurance and retirement. Okay. So I would say that what's the trigger? Having some type of an asset that doesn't have a beneficiary that's material. So what is a non-economic trigger? A child. And why is that? Because, as I mentioned earlier, there's usually a guardian. And the guardian and the trust and the executor do not need to be the same, nor are they usually the same. But again, like I discussed with the executor, the trustee needs to know and accept the responsibility of being the trustee, being the guardian of that child. And I will share with you, in my case, my kids are all over the age of maturity, although I think someone would still like a guardian. But basically, we changed the guardian 3 times. Why did we change the guardian? Because when they were young, my wife was from Minneapolis, and when they were young, we would have sent them to be with her sister and my brother-in-law in Minneapolis. And then when they were 7 or 8 years old, we'd say, well, we don't want them to be separated from the house they grew up in and their friends here. So it wasn't that, I also had a falling out with a relative. And who your guardian is something that you really need to discuss with your significant other. It's a very big responsibility. And normally, you would provide for the child through life insurance and a trust. And also, let's make another thing. Usually, if you're married, the whole idea of wills and trustees and executors is the second person to die. Because normally, the first person to die just goes to the spouse. The only time I see that out is if you're extremely wealthy. Then you want to try and move assets out.
Okay. All right. Is there anything else you want to add before we conclude today's episode?
Well, just you're talking about who needs a will. So I did say, buying a house would be a triggering event. Getting married wouldn't necessarily be a triggering event. Having a child, not having a dog or a cat, that we know. Although if you want to have somebody be the guardian of your legal guardian of your dog or cat, you should probably tell them that as well. No, I just think that we brushed a lot of high level topics. We went into a little detail, but I think that welcome anybody's questions. Monica's going to tell you where you can send your questions. This podcast I want it to be driven by the audience who listens and the types of things that they want to talk about. We certainly have. Our team's done a research on what are people thinking about, but what people are thinking about and what people want to ask may be 2 different things. So I certainly want to encourage that.
Right. So to that end, we invite everyone to visit onthemark.cpa. With any questions that you may have, even certainly very specific questions, we could reach out to you directly. Certainly won't reveal any confidential information on this podcast, but we're happy to share best practices or reach out directly if a specific question is posed. And if you'd like to be a guest speaker, we would welcome that communication via our website as well. So again, today's episode was sponsored by Zimmern & Company. We thank everyone for watching and or listening, and we look forward to seeing you next Wednesday. All content provided on this podcast is for informational purposes only. No representations are made as to the accuracy or completeness of information that is presented. On the mark, its owners, collaborators, and guests will not be liable for any errors or omissions, nor for any losses, injuries, or damages from the use of this information.